Hey, you guys. So we are remixing things a little bit. We will get to a flashback. We are going to look back at June 7th. That is the day that Woody got on the stand and pled the fifth, and Melnick was in the room. And now that we've looked through the transcripts, looking back at that, we're going to notice so much more stuff. I know people like Ann Stuff, Julie, a lot of the regulars in the chat here have noticed a ton of things looking back at that June 7th meeting. We're going to do it together in full. The clips that will be relevant are about an hour and 30 minutes total, and we'll play it on 1 1/4 speed. But we have some other things that I want to talk about, starting with yesterday. I noticed that Brian Steele had put together an appeal volume, and today we now have a Supreme Court notice of docketing with a new case number. So what that means, let me switch over here. So this is the notice of docketing. You can see the new case number is probably small on your screen over here, but we officially have a case of Brian Steele versus the state of Georgia. So we've got that. That's like brand new right now. So if you guys thought nothing was happening, it couldn't be farther from the truth. So there's that. Let people know. I also did want to talk, and actually if you guys want to see it over here, this is the Supreme Court docket system. So we've already seen these actions relating to the contempt and the request for supersedious bond. But here you can see right now, July 3rd, Brian Steele versus the state of Georgia. So really, really, really interesting movements happening this week, right before the holiday. So yeah, hit that like button, guys. We're talking about some breaking news here. We are talking about some breaking news. Good stuff. The other things I want to talk about, you guys may have seen yesterday, I posted a community post but didn't do a video because it's one page. We can round that up now that we're all together. So yesterday, the attorneys for Diamante Kendrick, or Yak Gotti, filed a motion to disqualify Fulton County Superior Court judges from ruling on the recusal of Chief Judge Glanville. The reasoning behind that is, he's kind of like their boss, they work together, and they want these recusal matters to be heard by somebody else. So we can read this real quickly here. The defendant, Diamante Kendrick, by and through his counsel, without waiving any other rights, files this motion to disqualify the Fulton County Superior Court judges. They say that they want to do this because even though Glanville recused himself from hearing it, it automatically got signed by Georgia's Odyssey system to Rachel Krause, another Superior Court judge. But based on case law and guidance from the Court of Appeals, they say that, quote, it is inappropriate for any trial court judge to preside in any action wherein one of the parties holds a judicial office on the same or any other court which sits in the same circuit. Now, it was one page, the next page is just a signature. But what's interesting is Rachel Krause was kind of getting right to business. So this was filed around the same time, and you may have already seen it in the community notes post. But Rachel Krause got right to work. She issued this order yesterday requiring written response from the state, from the prosecution, to 3 different recusal motions. And she gives a great reason, a reason that we should all expect. So this case, state of Georgia versus all the co-defendants, is before the court to consider motion to recuse Chief Judge Earl Glanville from further handling of the above-captioned case, 2 defendants and a counsel for a witness. Specifically, the motions are Diamante Kendrick's motion to recuse Judge Glanville from June 12th. That date's pretty important. Defendant Jeffrey Williams' motion to disqualify or recuse Judge Glanville from all further dealings, filed June 7th. And then non-party Kayla Bumpus's motion to recuse this court, filed June 14th. Now, her reasoning here, Rachel Krause says, time is of the essence, given that a jury trial is currently paused pending resolution of these recusal motions. Therefore, the court hereby orders the state to file a written response to the pending recusal motions on or before 5 p.m. on Monday, July 8th, 2024. So, what's really interesting about this is they're short on time, right? Tomorrow's a holiday. Tomorrow's a federal holiday. So court's not going to be open. Then you have Friday. And then July 8th is Monday. And even though it could be electronically filed at 11:59, Rachel Krause is saying 5 p.m. Monday. So they've got 1 business day and then through 5 p.m. on Monday. So 2 business days to issue these responses, not including today. If they started on this today, that would be 3. But at the same time, this disqualification request filed by Diamante Kendrick's attorneys, maybe that could be granted. And maybe that would disrupt this order responding them, because now it would no longer be Rachel Krause seeing the case. However, my best bet is the state, Adrian Love, ADA Hilton, are running to throw together responses to these motions. I think that's hilarious, if you ask me. Sounds really crappy for them to have to do, but they got themselves here. And then the last thing, which I learned from Joseph Papp, we had talked a lot about Belinda Edwards. Belinda Edwards was assigned a case automatically through the Odyssey system. She, sua sponte, recused itself from hearing it. Now, sua sponte means this court, me, the judge, I'm doing it on my own. I'm doing it without being asked. I'm making the sua sponte decision without someone having to make an argument and me make a ruling in response to that argument. And Belinda Judge said, look, I am a Superior Court judge, and pursuant to Uniform Superior Court Rule 25-7, if a judge, either on the motion of one of the parties or the judge's own motion, voluntarily disqualifies another judge selected by the procedure set forth in Rule 25-4, they shall be assigned to hear the matter involved. So she's taking herself out of it. This is interesting because it comes on the tails of Doug Weinstein making that same request. So that's our roundup. You guys may have seen that in community posts, but I thought while we start this live stream, why not round it up? Thank you so much to people like Drea, Julie, so many names and stuff. Heart of Inspiration. This is not an exhaustive list by any means, but you guys have been on fire with details and documents and crowdsourcing everything together. And that's really, really, really awesome. So other than that, you guys, let's, the thumbnail for this, the title of this was us looking back at the day that Woody pled the fifth. So if you guys are ready, we can jump over into that. And we're going to look at that with fresh eyes and see, do we notice anything interesting now that we know what was said in those transcripts? So I've got 2 timestamps. We'll go right to when the courtroom gathers as Woody's finally about to take the stand, because they took a while to take to get the court started that morning too.
Jurors present.
And I got to make this full screen, so let me pause this.
Okay, all right. Deputy Ham, can you check on our jurors, please? Mr. Steele, what can I do for you? Okay, all right.
Thank you, Drea.
John, just from my issues with the proposed exhibits, I don't know if the state's planning on introducing today, but I just want to give you a heads up.
And you guys give me feedback if you want it faster, slower.
Okay, all right. She said you'll deal with it. She'll deal with them as they come, as they're introduced. So, all right. Summon our jurors, please.
Actually, let me put a banner. Ian, do you mean no court Friday? Because that's even funnier. They've got like today and Monday morning.
All right, ladies and gentlemen, please be seated. All right, thank you, Deputy Ham. Ladies and gentlemen, the jury, good afternoon. All right. Without further delay, we're going to go ahead and call the next witness. State.
Your Honor, Ms. Hilton calls Kenneth Copeland to the stand.
All right, summon Mr. Copeland, please.
Your Honor, here's that. Mr. Copeland is.
All right, here it comes. All right, Mr. Copeland, go ahead and approach the witness stand. Before you sit down, if you would turn and face Deputy Ham to be sworn as a witness.
You swear affirm testimony to bring the court the truth, the whole truth, nothing but the truth, self?
Yes.
Maybe see if you state the first and last name, but spell them both, please.
You say that again?
State the first and last name, but spell them both, please.
Kenneth Copeland.
Mr. Copeland, do me a favor, pull your chair up as close as you can to the microphone and speak directly into it so we can all hear you. So if you could state and spell your first and last name for the record, please.
Kenneth Copeland.
So, please.
Spell it, please.
KennethCopeland.
All right, thank you, sir. All right.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am,
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Ladies and gentlemen, can I get you to step outside to your headquarters of jury deliberation, please? From
All right, for sure.
And all right, let's hit the pause button on that because again, when I had mentioned this in another video, I was like, I'm going to link to the June 7th, the timestamps in the description, but we're not going to rewatch that because we've seen it. But you know what? It's so interesting to watch in retrospect. And in this moment, we already know from the transcripts that Woody was saying for days. This was Friday, June 7th. He said that some of those days, Monday, Tuesday, Wednesday, Thursday, he had already been telling Hilton he was going to plead the fifth. So this moment when it happened on the stand, when we were watching it on June 7th in real time, we were like, whoa. But that was not a surprise to Hilton. That should not have been a surprise to Judge Glanville, maybe. It might have been if they left him in the dark when they had him sign that the immunity deal. And then this is before the ex parte meeting actually took place. But as we go through the rest of what took place after they take Woody out of the room, Attorney Melnick's going to come in. He's going to say, like, look, I tried to tell them that he was going to do this. And then Judge Glenn was like, I'm going to hold him in contempt. And then Adrian Love and Miss Hilton start to act like they're clueless, that this is some huge surprise to them. They didn't know this was going to happen. So seeing this all play out again after we know that that contemporaneously was not true is what's crazy. Let's keep going. Let's keep going. They're going to have to shuffle this guy right back out of the room. And watch the body language. We're not skipping body language because it's interesting.
Our jury has left us. Mr. Copeland, given the fact that you have invoked your Fifth Amendment privilege, but the state has already given you immunity under 24-5-507, this court holds you in willful contempt, and we'll see you on Monday. And we'll see if we can get some more testimony at that point in time. Take him into custody.
And as soon as they get him out, you can hear them cuffing him. Let's get to the arguments.
Mr. Steele,
Excuse, would you please entertain a motion for a mistrial?
Mistrial, let's go.
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him,
All right, democracy in the chat, or republic, whatever it's called, whatever we are going back to watch the body language when Miss Love calls Woody. Is this about right?
Copeland is.
I just.
Go back a couple seconds. It's right there. Now I'm getting the loading circle of death.
All right, ladies and gentlemen, please be seated.
All right, so everyone, we got to watch Miss
All
Love.
right, thank you, Deputy Ham. Ladies and gentlemen of the jury, good afternoon. All right. Without further delay, we're going to go ahead and call the next witness. State.
Your Honor, Ms. Hilton calls Kenneth Copeland to the stand.
All right. Summon Mr. Copeland, please.
She scoffs. She goes,
Your Honor, here's that. Mr. Copeland is.
Here it comes.
You're right about the
Go ahead and
judge.
approach witness stand. Before you sit down, if you would turn and face Deputy Hand be sworn as a witness.
Raise your hand. You swear affirm the testimony you're about to give according to the truth, the whole truth, nothing but the truth, so help you? You may be
That was the quietest yes. So let's get back to Steele making his motion for a mistrial. Like, the body language is
We'll come back on
crazy.
Monday.
And then, Your Honor, the jury is excused. Would you please entertain a motion for Ms. Scott?
Mr. Steele, I'll entertain it right now.
I didn't want to hold the jury, but that'll be fine.
And what's the basis for your mistrial? We didn't know he was going to invoke. We didn't know what he was going to testify to, and I certainly didn't let him.
Yes, he was
only
already
asked one
given
question, so
immunity.
at this point in time, there's really, I mean, you can't knowingly let a witness invoke their Fifth Amendment privilege in front of a jury, but that didn't happen in this case. Last thing we heard from Mr. Copeland was he was going to testify.
So everything you say, I'll adopt because I was about to say those words. Based on information belief, I'd like to call witnesses from the prosecution. I was told, I do not have the personal information, but I was told that Mr. Copeland made that known to officers of the prosecution team prior to being called right now.
But it's what I was told. I mean, the last thing the court knew, and he has counsel.
If the party knows that a witness is going to invoke the Fifth Amendment in front of a jury, which poisons us, I mean, there's no doubt it prejudices Mr. Williams et al., all of them, because this trial's been going on now, I believe, 8 months in front of a jury, and they've heard Mr. Copeland's name however many times a court reporter says.
Casey, that's what we've heard.
No,
So.
the jurors have heard Kenneth Copeland.
And as well,
I
okay.
opened on him that he's a killer. We cross-examined all these witnesses about Kenneth Copeland. The state talked about Kenneth Copeland. My point is, if this honorable court finds that the state knew or had reason to believe that he was going to do this in front of a jury, that his response was going to be, I'm invoking the Fifth Amendment, then, Your Honor, yes, I adopt what you said. That's wrong of a party, and I'm moving for a mistrial.
Okay.
Okay.
All right, sir. Thank you. All right.
Your Honor, our rules of evidence.
Yes, sir. It would apply to everyone. Yes, Ms. Love.
Your Honor, I'd just like to put some things on the record
Sure.
regarding Mr. Copeland. As we stated earlier, Mr. Copeland has.
I don't want to interrupt you. Your Honor, I'm just telling the court, I'm not accepting the proffer.
Your Honor,
Anybody can
if I may.
Okay, but counsel gets the proper, Mr. Steele. I can accept that. So could you sit down at this time, sir?
Sit down.
Okay, thank you, sir. All right, Ms. Love, you can complete your proffer at this point.
Your Honor, yes. Just to relate to the court, the observations that members of our office have made throughout the course of this morning and throughout the time that we've been dealing with Mr. Copeland. Our cause for concern is Mr. Copeland's communication that he is going to us, that he is going to speak, that he is going to speak on the stand, that he is going to testify, and watching what happens when Mr. Copeland gets on the stand. Mr. Copeland did not want to have to be taken into custody. The court gave him the opportunity to have present in court with him someone who is supposed to be representing his best interests. What we have seen is communication, both verbal and nonverbal, between Mr. Copeland's supposed counsel and counsel for defendants. And a look as if I tried from Mr. Copeland's supposed counsel in the direction of counsel for the defendants after Mr. Melnick attempted to assert for Mr. Copeland. May I finish?
Let her finish, Mr. Melnick. Please sit down. I'll let you start. Okay? All right. Thank you, sir.
While Mr. Copeland is on the stand stating that he wants to testify, that he will testify rather. So we are watching, and Mr. Melnick, I believe it may even be captured on film. The court can look at it. Mr. Melnick turns to the direction of counsel for the defendants and motions like, that's it. Then, upon information and belief.
Now, I want to say that that's an interesting call out too, because during the transcripts, from what we can see in the transcripts, Miss Love also misrepresents email communication sent by Mr. Melnick. She says, look, Mr. Melnick emailed the defense attorneys, Shart, Steele, and also CC'd me and Hilton. But Like a page later, she's acting like she was left out of those communications. So for her to make insinuations about Melnick's body language now or something that may have been going on in the courtroom, to me, it's just so disingenuous. It seems like projection. It seems like she already knows she's in the hot seat because they've been trying to get this witness to get on the stand when he's been telling them he's going to plead the fifth. And he gets on there and does it anyway. And we've got the attorneys, the defense attorneys saying, mistrial, hello. And Love is just trying to point the misconduct finger at somebody else, to Melnick. Like, just think about this in the terms of this was Friday, June 7th, the last day of court before the ex-parte hearing took place that Monday morning. And after the plea deal was signed by Judge Glanville. Like, this is crazy. This is crazy.
As we are standing out waiting for the jury to come in, Mr. Copeland requests to speak with counsel for the state, but Mr. Melnick keeps walking in. Then, as
Does he at any
Mr.
point in time tell you?
Copeland,
Does he at any point in time tell you I'm not going to testify? I'm invoke the Fifth Amendment.
no, as what happens, as Mr. Copeland requested to speak with the state, Mr. Melnick keeps going in regardless of Mr. Copeland's request to speak with the state. And then we learn that Mr. Melnick tells Mr. Copeland they are going to hammer you. So Ms. Hilton comes back in and asks me, had I spoken with Mr. Melnick? Had I told him that we are going to hammer Mr. Copeland? The state had not made any such communication with anybody. So what we are seeing, we believe, is tampering with witnesses, this particular witness on the part of people who are not the state. So we are concerned. I don't know that Mr. Copeland's interest is being represented when that interest may not be in alignment with the people that Mr. Melnick is communicating with on breaks. And after Mr. Copeland has communicated to this court, he will testify. So watching the goings on as Mr. Copeland is not on the stand, it has been publicized. It has been hyped up that Mr. Copeland is the next witness. Mr. Copeland is the witness. And then Mr. Copeland, he's been nothing but cordial. He's been nothing but communicative with Ms. Hilton during the time that she has been interviewing him and speaking with him. And the reason
All those times she was interviewing with him and speaking with him, but guess what? We saw in the transcripts that was not recorded. Those meetings were not recorded. So he's cordial. He's so great. And no, we don't have any paper trail of that. Like, come on.
Ms. Hilton was not in here just now when the jury came out is that Mr. Copeland asked to speak with Ms. Hilton. But Mr. Melnick kept going back in there and going back in there and going back in there. And the reason that we have a problem with this is that Mr. Copeland is not facing any charges. For Mr. Melnick to suggest or say to him that we're going to hammer him, it causes us to call into question whose interest he's representing. And so we would ask that, you know, what I haven't even thought of in my mind an appropriate remedy at this point, because it is wrong for parties to inject themselves on behalf of purportedly one person. And I don't know, I guess they're, I don't know what's going on, but I can say that this entire day, starting from the point at which Mr. Melnick is invoking Mr. Copeland's Fifth Amendment right after Mr. Copeland has said he's going to testify, has gone a little off rails, and it's a little bit concerning. So, Your Honor, as to this motion for a mistrial, we would argue that it's caused by actions on the part of people other than the state, that Mr. Copeland got here and said what he did. So we will continue to speak with Mr. Copeland because Mr. Copeland doesn't have any charges that are open. If he asks to speak with us, which he has, we'll go and speak with him. I'm not even certain what is going on behind me with respect to persons who are purporting to represent the best interest of Mr. Copeland. But it would appear to me that Mr. Copeland's best interest would be served by Mr. Copeland not being inside the Fulton County Jail. But that's just my opinion. So, Your Honor, I would ask that the court deny the motion for a mistrial at the very least. And if it goes any further, find that actions by people other than the state have led to us being where we are, because Mr. Copeland was at the point right before lunch of agreeing to testify. That is the reason we were ready to get started right before lunch, because now he's been told he's going to be hammered by his attorney. I guess he told him that I guess the state's going to hammer him. I don't even know what, but Ms. Hilton has gone over the questions that she has for Mr. Copeland. She has spoken with him about it. They have been speaking cordially with one another. And this idea that somehow someone is entitled to mistrial as a result of this action on the part of Mr. Copeland is a farce under these circumstances.
So she's calling it a farce, but hold on. How long? We are at timestamp or 24 minutes. When did she get up there? When did she get up there? She's up there at least 8 minutes. Just over 8 minutes she's up there. And she says two things essentially that whole time. She's basically saying, we didn't know he was going to plead the fifth and he's been cordial with us. And then their body language. It's everybody but the state. She's going on for 8 minutes. Woody loves us. If something's wrong here, it's not the state's fault. 8 minutes of that. like, come on. Oh my gosh.
We'd ask that the court deny the motion.
All right. I'm going to deny the motion for Mr. Mr. Steele at this point in time. I'll note that you've made it. And I'll let Mr. Melnick in just a second make whatever remarks he wants. Do you have anything else you want to say?
Yeah, I would like, but my understanding is, I'm going to proffer this. But there's a great investigator who is looking at me and I trust her. I'd like to call her as a witness. I was told I was not there. I was told that, and I forget her name. I know her first name, but her last name. And Investigator Long, and I may be wrong, heard Mr. Copeland prior to coming into the courtroom, almost immediately prior, state, and I'm reading.
Did you see their face in the corner? Hold on, look at their face in the bottom left. Let's go back 20 seconds.
Prior to coming into the courtroom, almost immediately prior, state, and I'm reading from Mr. Kokomo. If I have to go to jail, then lock me up. And then the Honorable David Botts told me as I was walking in that he heard, he's right behind me, so he should be speaking for himself, but he heard Kenneth Copeland tell the prosecution, I said the wrong people, please correct it, that he's invoking the fifth. That's why I raised it. I'm not saying anybody did anything wrong. I'm saying that if a party knows or has a reason to believe that a witness may invoke the Fifth Amendment in front of a jury, we avoid that at all costs.
But the challenge we're having, Mr. Steele, is I do believe that there's probably been some behavior that probably wouldn't pass the good faith test of there's a lot of influences inside and outside. So I'm going to basically base it on the proffers of counsel and just remind
Look
you
at
all
Shart.
of
Look at
your
his face.
responsibility requirements. Okay. So I'm going to.
Reminded all the time because I live them. I'm just telling the court that in order for you to deny my motion for a this is bad.
And I'm going to deny your motion, and I've made my ruling. So I'm done at this point in time. Okay. In terms of this motion for mistrial.
Well,
Melnick is ready. He's got the hands.
I'm not going to call any witness. I don't need any witnesses. Your proffers are fine. Okay.
Can I add a proffer?
Yes.
As you know, we are in a side room off the hallway on the first floor. That's where defense counsel, it's kind of their conference room. During lunch, I'm working on unrelated matters, and I'm going to get a ginger ale to calm my upset stomach. And I'm on the phone, but I'm hearing a gentleman speak very loudly on the phone with agents from the state. To my belief, agents from the state were present within earshot. And that gentleman on the phone, who was Kenneth Copeland, was making.
How do you know it was on the phone? If Kenneth Copeland's on the phone, was he talking on the phone or?
He's standing in the hallway 10 feet from me, practically screaming in the phone.
Oh, so Mr. Copeland's on the phone?
Yes.
Okay, and you're overhearing this particular purported conversation?
I'm not testifying. I'm not giving a direct quote because I was on the phone handling my own business and I was having no interactions with.
Okay, but here's the thing. I think it's consistent with I'm not testifying. Okay, he can make a decision not to testify. Okay, but if he does so, and because he's already been told, look, you can invoke your Fifth Amendment privilege and you've been given immunity. And if you don't, I told him what the consequences are this morning. That's consistent with what I've heard thus far. And I don't think that is.
I believe that the state was on notice that something like this.
Okay. All right. But all of you have kind of, like I said, either unwittingly or I just remind you from outside agitation or otherwise, you all need to stay away from any of this. You do. Both sides need to do this. Do not let outside influences.
Both sides need to do this. Both sides need to do this. And like 3 minutes ago, he was saying, it seems like this might be bad faith, what the defense is trying to do. Something's going on. It's not the state, it's the defense. Like, this is crazy. And Chill, that's hilarious. He says that this is like a disappointed referee after the players argue the foul.
Influence your actions and get you in trouble. You all should rise to a higher standard in terms of don't Don't let any of this up. I mean, these witnesses will testify to whatever they're going to testify to. So
The defense has done nothing.
I didn't say you did anything wrong. Okay, but
All
I
I've heard is that the state,
I didn't say you did anything wrong, but
but I understand,
okay.
Your Honor, but I just want to be clear. The only thing that I've heard today is that the state met with Kenneth Copeland without his attorney.
Are we going back to that again? I thought we.
I don't know of any
Okay.
defense counsel that's had any conversations with Kenneth Copeland at all. And I just want to make that clear. Today, I don't know of anyone that's had conversations with.
Okay, but he's their witness at this point in time. If he wants to talk to you or he doesn't want to talk to you, he's got a lawyer, and that lawyer can make that decision, and so can Mr. Copeland. So
Side situation because we.
I understand that, but you can't let other people, and I would advise you not to let third parties influence what you may think a witness is going to do.
That's not happening.
Okay, and that's all I was trying to tell you. Okay.
Okay.
All right. Yes, sir. What does he like to tell me?
So for anyone that's not already familiar, this is Attorney Melnick that's walking up right now. Before we let him speak, and it's going to be great, Dre is letting us know that Copeland posted, Kenneth Copeland is Woody. He posted on his Instagram that he was going to plead the fifth. That's hilarious. That I didn't know. And half this case has been based around social media posts. Like half the investigation work, their leads are coming from social media posts, or if not song lyrics, or someone standing and holding up a gang sign in a picture. So for him to be on social media making this this type of statement, you think that Hilton isn't looking at stuff like that, or their investigators aren't looking at stuff like that every day? And secondly, he went live yesterday, and I went in there, and he said he's still not telling on himself. What do you think, I'm stupid? Like, and then the trial's paused. If we get a mistrial for prosecutorial misconduct, hopefully retrial's barred. And Woody may never have to take the stand in this case again. But if he does, he was still saying yesterday, he's not telling on himself because he's not stupid. like it's just... And this is another great point. So my French isn't good, but Publier du Monde, he says, seems like Woody called someone post ex parte and told them that that's how it got back to the defense. And at this point, Kayla Bumpus isn't in the picture. This is still with Melnick. Kayla comes in on Monday morning on the 10th. So all of this is already in the awareness of everybody in this room right now, but even before this hearing started, today's trial started, the radar was there. Things were on the radar. And then on Monday, when Steele makes his inquiry with Judge Glanville acts like everything was a secret. How did you know about this? But they're really talking about all of it right now, already. So why wouldn't the defense attorneys kind of put two and two together as soon as they were missing for 2.5 hours on Monday morning? Like, I thinking about it in retrospect, it's really weird that the judge tried to act like anybody was surprised that this meeting was taking place. Because he says at the end of the day today on June 7th, we're going to meet on Monday morning to make sure Copeland's going to take the stand. The reason we're going to meet before is to ensure that this witness gets on the stand to deliver testimony. And then he acts like it's some big shock that Steele and the other defense attorneys have questions about that meeting and any possible prodding of this witness. So by then, Kayla's not the one that disclosed some of this information. It's already being disclosed, if not already just obvious from anyone standing in the hallway and hearing Woody on earshot screaming into a phone. Right? There's no expectation of privacy if you can overhear things. Like, a lot of this is just crazy. Melnick's about to lay down some fire, and Love is going to get really mad.
Mr. Melnick.
Judge, I went back and reviewed my communications with the Fulton County District Attorney's Office in relation to Kenneth Copeland. And I found communications as late as June 5th of last year, where the Fulton County District Attorney's Office had reached out to me about speaking to Mr. Copeland. Speaking to Mr. Copeland concerning this trial, not about any other case, speaking with Mr. Copeland about this trial. Neither of these attorneys, no attorney at this table has ever attempted to contact me about Mr. Copeland and about his willingness or desire to testify at this trial. They have put us in this position where at the last minute, I'm trying to advise him as best I can what I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that I'm not going to reveal.
I don't want you to do that, sir.
I can assure you that the decision to invoke the Fifth came completely from Kenneth Copeland. I owe nothing to anybody over here. I owe nothing to anybody at any of these tables. I don't care, candidly, no offense, don't care what happens with their cases. The only thing I care about is what happens to Kenneth Copeland. And for any assertion, I'm sorry, Judge, for any assertion.
And that's your primary duty.
It is. That's exactly right. And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations.
Look at her. Look at her language.
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only rule upon what I see. Okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, I'm going to invoke my Fifth Amendment privilege. The state came to me and said, okay, listen, we would like you to sign an immunity order under 24-5-507. They make that decision. So there are, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was privileged. So
absolutely no.
So, but in order.
Oh, come on, feed. The timer's still going, so this is 11 Alive's feed.
Your client this morning. So whether or not he wishes to go ahead and still invoke his privilege, that's his choice. But the statute's pretty clear.
I understand.
And I know you probably, and I know you have known you, sir, for at least two decades or more, sir. And I know that you have told him, hey, look, if you invoke, this is probably what's going to happen. And I suspect that if you probably have a conversation with him now, you're probably going to tell him, well, that was a self-fulfilling prophecy in terms of what I told you might happen. But I don't know what conversations you have with them, but I suspect that they were consistent with what the dictates of 24-5-507. Now, Monday, we'll go ahead and I'll call him out before the jury comes in on Monday morning, and we'll ask him whether or not he wishes to continue his testimony, because I don't want him to invoke in front of this jury if I can help it. So since he's made it once already, I'm going to ask him before the jury gets out here on Monday, is your intent to invoke your Fifth Amendment privilege? If it is, he's going to go back into custody until he's willing to go ahead and give testimony, because he has immunity, so he has to testify.
Judge, the only thing that I would say is that the primary reason Mr. Copeland is in custody right now is because the state has utterly failed to follow up with me in any regard with regard to what Mr. Copeland wants to do or intends to do.
I suspect that that's probably not true.
It is grossly unfair.
That's probably not true.
Decades, I've known Ms. Hilton and Ms. Love in particular for a long period of time, and I don't think that they would do that to you.
Judge, at no point did they ever reach out to me about Mr. Copeland. About Mr. Copeland's testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
When I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because.
When did you talk to Mr. Copeland?
Last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understood that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays, when we picked him up for the first time, on Tuesday, when he did not take the stand, we went upstairs. We had some conversation. We left. Mr. Long took him back home. And then yesterday, he came back down here with us. Again, we showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, or whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client, and then my client's going to plead the Fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid, or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But whether or not
And answer my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my.
Now, first, I want to pause and say thank you so much, Rhodes, Dogs, and Conversation, for the super chat. Do you have a channel? Because Dogs and Conversation sounds like a channel. And I like dogs and I like conversation, so I might have to come find you and subscribe. But thank you so much for supporting this stream. I also want to point out Hilton's taking issue with Melnick possibly being the one to initiate a phone call to Woody. Does she know everything that Woody does every second of the day? How do you know that Woody didn't try to call him and he was returning the call? How do you know that Woody wasn't trying to speak to Melnick all week? And maybe successfully did so, or maybe didn't successfully reach him or whatever. But really that's neither here nor there. What does it matter if Melnick was the one that initiated one phone call? We don't hear Hilton say, I have knowledge that was the only phone call between the two of them since June of last year. What is the relevance of pointing out that detail in isolation if you don't know the rest of the context? That's not nefarious at all, really, on its face. But she's trying to make an insinuation that someone's prompting Melnick to show up out of nowhere for no reason, unfounded, maybe the defense counsel prompting him to do it, and that he shouldn't be doing that. Woody shouldn't be receiving a call from him. She got up twice to make sure she got that out. That's weird. That's weird. And ultimately, I think it's an attempt at mudslinging. Oh my God, Melnick called Kenneth Copeland, and we're the only ones that are allowed to have cordial conversations with Woody. My
client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules. Okay.
Of course.
And that sometimes has to be explained to witnesses and clients. Okay. All right. So that's where we are at this point in time. Is that Monday morning I will bring Mr. Copeland back out. It is I don't relish the fact of holding him in contempt, but that's all I have at this point.
Get the last word, love. Get the last word.
We'll take him up because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial, because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony.
Why would he be familiar? Why would he be familiar with the statute already? We've heard that those papers were handed to Copeland during the ex-parte meeting on Monday. How many times have they showed this guy this statute? Why do they have to keep showing him? You wouldn't keep showing him something like that if you didn't know he didn't want to testify. Oh, sorry, look at me. I hit the timeline instead of the play button. But in the meantime, while I get back to wherever I left off, Julie, this is a great point too, that Woody didn't say Melnick wasn't his lawyer. He said he hadn't spoken to him. And in any other situation, how far back did I go? Okay, we're here somewhere. This looks like where she takes the mic. So we'll leave it there. But not talking to an attorney just means I haven't had a chance to reach him. Or I haven't reached out yet. It doesn't mean I don't want counsel for whatever I'm about to be doing. And that seems to me like another manipulation, another play on words we're seeing on June 7th in the midst of all of this. Andrea with another good point that Woody's name wasn't announced as the next witness until Thursday, and accidentally. She says, I believe that was by the state's design. It's another way to keep his attorneys in the dark. So keep the attorneys in the dark and, you know, kind of put in this panic. We find out in the transcripts that Hilton was aware that Kenneth Copeland's child had a birthday coming up. He ends up being held in contempt over the weekend. Woody's not very happy about what he had to miss while being held over the weekend. And then I also saw this. So Speedy Gonzalez pointed out that nobody's discussing why they didn't refresh Woody's memory with the interrogation video. Obviously, he doesn't want to be there. So I think it was following like the first day when they started to try to talk about some of the videos. Shart got up there and he raised issue with this. He was like, look, why, this seems weird. Why didn't the state prepare this witness like they should be doing with every witness? Did they not do it with this witness? Why didn't they prepare this witness by refreshing his recollection with these videos? And that's a really, really great question because they're having all these conversations with Woody. These great cordial conversations. But yet they're not prepping him to try to refresh his recollection like they would do with any other witness. Why? Because they probably wanted him to be inconsistent or give contradictory statements on the stand so they could introduce more through impeachment. That's my theory. That is my theory. And yeah, I think this is where I was. So sorry I just flubbed and...
Because I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime that someone did not want to speak with us,
consistent with what the dictates of 24- about
Where did he take his mic?
What I think is best for him. Had they exercised the slightest bit of professional conduct, we would not be sitting here having this conversation today. And unfortunately, for me to fully explain everything that's been going on, it would require me to reveal confidences that...
Okay, and sir, that is whatever you decide to do outside of what the court is ruling upon. Remember, the court can only
Sorry,
rule
I just
upon
struggle
what I
streamed.
see, okay, and what I see at this point in time is a witness who, for whatever reason, may have some other reasons about his testimony. He has expressed those this morning. He said, "I'm going to invoke my Fifth Amendment privilege." The state came to me and said, "Okay, listen, we would like you to sign an immunity order under 24-5-507." They make that decision. So there are, I mean, I think that gets us to the point where we knew that, or at some point in time, that the state knew that he was.
Okay, we were way past
privileged.
this because
But
this is where
in
it's
order-
glitching.
I'm going to ask him before the
testimony here today. The last time I heard from anybody in the Fulton DA's office was June of last year.
Ms. Hilton, did you reach out to Mr. Melnick? And if so, when?
when I talked to Mr. Copeland, he told me Mr. Melnick was not his attorney. So that is, I talked to the witness because
When did you talk to Mr. Copeland?
last Friday, because my understanding prior to that is that Mr. Melnick had told Ms. Love that he wasn't his attorney. So when we went to go serve him, I understand that he did not have an attorney. When I met with Mr. Copeland, and this is Friday evening, Mr. Long and I went to go meet with him in the car. We said, hey, I think Mr. Melnick's your attorney. He said, Mr. Melnick is not my attorney. He said, I haven't even talked to him. And then that is when we proceeded to begin our conversations. Anytime Mr. Copeland did not want to speak with us, we did not speak with him. We called him on Monday to see if he could come down here. He said he didn't want to come, or he didn't respond. We left it alone. On Tuesdays when we picked him up for the first time, on Tuesday when he did not take the stand, we went upstairs, we had some conversation, we left. Mr. Long took him back home. And then yesterday he came back down here with us. Again, we showed him some of the evidence that we were going to show him, and that was the extent of it. And if at any time Mr. Copeland would have told us he wanted his attorney present, we would have called Mr. Melnick. But our understanding was, one, he was not his attorney. Mr. Melnick disavowed being his attorney, and Mr. Copeland told me he wasn't his attorney. So that is what I based all of my decisions after. It was not until 6 o'clock last night, whenever this email was sent from Mr. Melnick with Mr. Shard and Mr. Steele copied on it, that I get this idea that you've been talking to my client and that my client's going to plead the fifth, which brought us here today. That has been what has happened since last Friday, Your Honor.
All right. So we have a witness that may not have been totally candid or may not have thought that he potentially needed you. And as things developed, Mr. Melnick, he decided, well, yeah, he does need you. But, whether or not.
And Mr. Ashram, it's my understanding that Mr. Melnick called Mr. Copeland last night. So it wasn't that Mr. Copeland called Mr. Melnick. Mr. Melnick so happens to call him the night before he's supposed to testify. So I don't know what has happened or what has transpired, but that is the extent of what occurred.
So I'm not going to get into my conversations with my client.
No, and I don't expect you to. But I do want to remind you, Mr. Melnick, as well as I reminded both sets of counsel, that you owe a higher duty of tribunal to me and the court than you do anybody else. So please don't, you as a professional advocate, don't put yourself in a position where you come cross purposes with the rules. Okay.
Of course.
And that sometimes has to be explained to witnesses and clients. Okay. All right. So that's where we are at this point in time. Is that Monday morning? I will bring Mr. Copeland back out. It is. I don't relish the fact of holding him in contempt, but that's all I have at this point in time because he's been given immunity. So we'll take him up because that's our first session of court. We won't be having anything else until then.
And Your Honor, I would like to ask that the court convey to Mr. Melnick, to convey to Mr. Copeland that he is subject to being committed and held in the Fulton County Jail until the end of this trial, because I'm certain Mr. Melnick, if Mr. Melnick wants to convey to us some of the concerns that he has, Mr. Melnick I'm certain is quite familiar with the statute under which the court has compelled Mr. Copeland to provide testimony. So there is nothing that we could do to Mr. Copeland regarding any testimony we elicit from him on the stand pursuant to the court's order under the statute that the court has cited, 245507. And that statute gives the court the ability and probably, depending on how the court feels about it, the absolute duty, given the necessity of Mr. Copeland's testimony, to hold Mr. Copeland in the Fulton County Jail until he decides to purge himself of the contempt of court by providing testimony. If Mr. Melnick would like to speak with Ms. Hilton or any other member of the state regarding his concerns about that order, which tracks the statute almost verbatim, then I would invite him to do so. Otherwise, as I've stated, I don't see it being in Mr. Copeland's best interest to be confined to the Fulton County Jail until the end of this trial. But I will leave those matters to Mr. Melnick, who at this time is asserting that he is representing Mr. Copeland. But again, that was not the understanding that Mr. Copeland had previously given to us.
Okay, so Mr. Melnick, if you do in fact talk with Mr. Copeland, like I said, I'll bring him back on Monday and we'll see where we are at that point in time. Okay. And he has the ability to purge himself by just providing testimony consistent with what he knows or what his knowledge of is in this case. Okay.
Judge, I have some personal matters that I need to convey to Chambers, but I'll do that off the record.
Okay, I'm going to recess in just a little bit, and but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do.
This is my favorite part when they sit back in tandem together. It's my favorite part. Like,
but can you be back for Monday morning?
That's just it. I can't. Is this something I can take up off the record?
Well, I kind of have to call him on Monday. I do. I mean, there's no choice. I have no choice because that is the next session of court.
Judge, I have non-refundable tickets out of town on Monday. I can't be here. I cannot be here. And there's nothing I've had this on file with Fulton County since December 15th of last year. And again, had the state contacted me before today, I would have made them aware of this.
Well, there's one of those times as a lawyer that you're going to probably have to kind of figure out a solution, sir. I mean, I don't want to put you in this particular position.
I can't be here, Joe. I absolutely cannot be here.
Well, you have a choice. You can be here if you want, but you'll have to figure out some other things to do with your tickets. I mean, here's the thing. If you're asserting, if the state was relying upon the fact that you were not his counsel, and now you are, you have put us in a situation where now, you put yourself in between a rock and a hard place. I mean, so he's coming back on Monday.
I'll have somebody else make my
then that can be done. And sir, I would advise you to do that. But remember, Mr. Copeland, has to have some concurrence. So maybe before he leaves and goes actually to the Fulton County Jail, you may need to have a conversation with him about that. So we're clear, and I'm clear as to whether or not you're coming back on Monday or somebody else is. And I need to know who that lawyer is. Do you want to have a conversation with him before?
Talk to him right.
All right. Okay. I'm going to allow you to do that, and then I'll remain and be available for a further discussion. So let me go ahead and Sergeant Ham, can you and your colleagues or Lieutenant Walker arrange for Mr. Melnick to talk with Mr. Copeland, please? All right. And I'm going to go ahead and at this point in time summon our jurors, please. All right.
so they're gonna send the jurors into. Hi, we're closing things again. We have another issue with the witness that just got on the stand for 3-4 questions and pled the fifth when asked to specify how old he was. What do you think he's thinking about right now? Oh my God, Otto, hi! Oh, thank you, Otto. You guys say thank you in the chat to Otto for dropping in some gifts. And if you didn't know, you have to click the little $ next to where you chat and turn settings on to be able to accept gifted memberships. YouTube gives them out randomly, but say thank you to Otto, especially if you got one. It's always good to see you, Otto. Is she shaking? I didn't notice that before. Wow.
All right, thank you, Sergeant Ham. Promoted you already again. All right, okay. Ladies and gentlemen, jury, good afternoon. Okay, it appears that we have some more homework to do, and given the fact that that needs to occur, my suggestion is that we go ahead and recess you for the day, okay? And let you begin your Friday.
And then heck yeah, Otto rules.
Ladies and gentlemen, Monday being a regular work day, what I'm going to have you do is report for 8:30 for a 9 o'clock anticipated start time. And we'll see where the day leads us on Monday, okay? All right. Any ministerial inquiry with me, ladies and gentlemen? Anyone? Okay. All right.
8:30 start time on Monday, June 10th.
All right. Unless you have anything of me, ladies and gentlemen, let's go through your admonitions at this point in time. Remember, leave your notepads in your headquarters, your jury deliberation room. Please don't take them with you. Remember that as you leave here and you gather, even outside our presence and hearing, to be in your headquarters, or as you go to whatever conveyance that takes you to your home within our great county, or if you're just in the halls eating or whatever, remember that it would be a violation for you to discuss this case amongst yourselves in ones and twos, or handicap the testimony, review the testimony, or otherwise give your thoughts or impressions about any witness that has testified thus far. Remember, you can only consider this case probably when the court gives you at a time.
Hey, DWC. Thank you guys so much for shouting out Otto. That's really nice of you guys. Otto is super awesome. Super, super awesome. And that was very awesome for Otto to give gifts to you guys. I can't believe he told the jury, see you come in at 8:30 on Monday.
That you cannot consider it in any way until such time as the court instructs you. Remember, it would also be a violation for you to add to your understanding, as I call it, meaning phone a friend, get a resource book, go to a website or any other source that to aid you in anything that you've heard thus far in this courtroom. Remember, you can only consider what's been lawfully presented and within the four walls of this courtroom. You cannot consider any outside sources, people, or otherwise reference materials to aid or augment your understanding. The other thing you cannot do is to go by any scenes that you may have heard about or may have been testified to in this case. You've been shown a bunch of maps and other audiovisual aids at this point in time. You are not to go by and visit any of those scenes. You're not to go by and take any pictures, do any sketches or anything like that, or share any other information you may know about those particular sites that you may have knowledge of. Remember, you can only consider what's been lawfully presented within this courtroom, okay? All right. Also, ladies and gentlemen, if any third party or would attempt to talk with you, reach out to you, email you, text you, or otherwise call you in any way to potentially reach out and communicate with you about this case, remember you to let myself and Sergeant Ingram know immediately. And then, ladies and gentlemen, and lastly.
Sorry, I know they give these rules every time they have to send the jury home. But it's just comical now to hear this recitation of the rules, especially rules pertaining to communications. You know, the judge also has a duty, part of the rules of judicial conduct. He's not supposed to go and learn things that aren't available, things that might be off the record. But what do we find out from not just the transcripts, but this week when Judge Glanville announced, hey, I'm going to send these recusal motions to another judge. I'm not going to hear them. And also, just so you guys know, security, I didn't inquire about it, but security told me that there was footage of Kayla Bumpus talking to defense counsels. I didn't inquire, though. We've joked about how he didn't know the difference between civil and criminal contempt. But there's certain rules that he's clearly well aware of, enough to recite them. And it's making me think about how he injected this mention of security video that his team brought to him, that the deputies brought to him. He knows he's not supposed to go and inquire and find things out that aren't part of the record of the case. But he wanted to talk about that video. And through that video, introduce this visual of Kayla Bumpus speaking with Brian Steele, Keith Adams, and Max Shart in the hallway. I don't know. So I just always think it's interesting hearing him read the rules now, because he doesn't seem to follow them.
Sessions, you know, we are really appreciative of the patience and attention that you've given to this particular matter, and we'll continue to give to it. And we state that to you. And our jury has left us. Please.
All right. And thank you so much, Otto, again for another 5 gifted memberships. You guys show Otto more love. Otto deserves all the love, especially, you know, when you see a dog in a profile picture, that makes it 10 times easier. Like, super awesome. Thank you so much, Otto. And then Moses Dupree with the $4.99 super chat. Moses says, Kat's live streams are the most entertaining thing on TV right now. Well, yeah, because the trial's on pause otherwise. And you know what? Since some of you guys are new, if you missed the very beginning of this video, the very first thing announced is that Brian Steele has now filed with the Supreme Court of Georgia. We now have a new case, Brian Steele versus the state of Georgia. So if we get, you know, that initial petition, we can look at that filing. We might be able to do that too. I just saw it posted to the docket that happened. Other than that, we are replaying the June 7th, that Friday, the hearing before the ex parte meeting the following Monday. So thank you for your support, Moses.
Please be seated. All right. Anything else I need to take up with you all? I'm going to recess in place to allow Mr. Melnick to finish talking with Mr. Copeland and find out if he or somebody else at his stead is going to be here on Monday. But if not, we will be here on Monday at 8:30. Any other things I need to consider?
Yes, Your Honor. There is a matter regarding the jail calls that we were provided. Mr. Steele has not yet provided us the ISO file. We received something additional on a thumb drive last night. We had the deputy of our jail call unit look at that, and we are again missing. We do not have the complete file
To be able to play
to be able to access it properly, to be able to look at it, authenticate the calls, the time of day, all of that. We don't have it. We were provided last night a thumb drive with cut and pasted file names up.
Thank you so much, Errol.
With some additional pieces of a file that would have had to, again, have been deconstructed from the way that the file would have been given to counsel for defendant Williams. We are asking the court to compel defense counsel to turn over to the state the file in the original condition that it was given to them, so that we may properly access and evaluate the content and the time and date and all of that, and the authenticity of those calls on that file. It has been deconstructed, and particular parts of the file have been extracted and purposefully kept out of what is given to the state. So we are asking, again, that the court compel either, you know what? And if they don't want to, then we're asking that they just be excluded.
Okay. All right, Mr. Steele, do you have the raw file?
Judge Glanville,
Sir.
you allow another moment when Ms. Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation just machine. I gave the state everything. There's been no disconstruction. There's been no purposeful. I don't care. I don't care. I give over everything. I've done this for 33 years. Never in my life have I seen a trial. I've done 300 appeals in the state of Georgia alone. I've never read a case like this. Judge, I gave them everything I had. I waited. I was at my office till 8 after 8 last night. I waited for their investigator to come by. I handed him an exact copy of thumb drive. They have everything that we got.
Interesting. Was it Cavell? Are you still in the chat? Because Cavell had mentioned way earlier in the chat. I don't even want to try to scroll for it because you guys are chatting and I appreciate that so much. It's so fun to watch you guys chat, but I can't keep up with it all the time. But Cavell had mentioned, I think it was one of the DA's investigators that may have told Brian Steele. And right here, Steele said, last night, the investigator, I gave him the thing in full. So they, you know, maybe it was just a high and by to exchange the information really quick, but maybe that was the moment some chit chat happened. I mean, not for nothing, but don't forget that Brian Steele has been practicing in this county, in this district for a very long time. You're going to run into the same investigators. And if the investigator, maybe they just blathered, maybe they said something. Maybe they felt something weird was going on and they wanted something to be done about it. But Cavell had presented that theory earlier in the chat that it was one of the DA investigators that may have been letting the defense know more was going on.
From the Fayette County Jail, there's been no deconstruction. There's been no purposeful exclusion. This is not the first time.
Okay.
And I apologize that I'm getting tempered, but I've never been treated like this. You talk about professionalism every week. Professionalism is lacking with one lawyer here. It has never been. I don't even like coming to court. I used to love this. I would die for what we do. I used to say, I'm dying. I would die. I couldn't choose a better profession. If I had litigated with Miss Love, I would.
Your Honor, could we strike the
No,
hominem
I'm
attack? Really,
speaking.
could we strike that?
Okay, hey, everybody.
She is so sensitive to what she feels like is a personal attack. Brian Steele is making an argument. The point of his argument, I'm tired of being accused of doing something incomplete or not being prepared or doing something in bad faith. Why is Love always accusing me? And then Love is like, personal attacks. And she's supposed to specialize in dealing with difficult witnesses, but I feel like she would be a difficult witness herself. Like, oh, and thank you so much, Penny G, for the $10 super chat. So Penny G says, ex parte meeting transcripts, DA's Love, Hilton need to be disbarred for violations including meeting with a witness, knowing he has counsel. Melnick was never served notice of withdrawal as counsel since 2023. Yeah, and then that's why it's crazy looking back. I'm going to bring this down just because it's weirdly positioned. But that's why it's so weird when you're rewatching this today and you see the back and forth, the discourse between, really it's Love butting heads with Melnick. Hilton doesn't say all that much. She chimes in a little bit, but it's really Love that's going back and forth with Melnick. And you have Melnick stating for himself, like, they didn't contact me and I'm about to be out of town. But Love could have seen from the records, hey, maybe we should just try to reach out to Melnick. Let him know that we're calling this witness. And there may be a possible issue with him wanting to plead the fifth. And they just don't do it. They just don't do it. And then they play dumb. They spend 8 minutes explaining away why they didn't know that they should try to reach out to Melnick. So thank you for the super chat and the chance to rant.
Calm down. Everybody, both of you, please be seated.
Judge, I'm not
Both of
done.
you, please be seated.
You have to do something. You have threatened me with contempt. You have threatened me with jail. If you go back in time, we can just start in voir dire.
Look at Hilton.
Did individual voir dire painfully. Miss Love would come in and say that juror was crying. It was not true. You would say that's not my recollection after I said it. You did nothing. We start the
Okay, but
case.
Mr. Steele.
I asked you, please.
Mr. Steele.
How would you feel if you were being treated
Mr.
like
Steele.
this?
Mr.
Oh,
Steele.
I'd like to finish.
Mr. Steele.
I gave them everything on that drive, and it's continual abuse of a prosecutor of another member of the bar. I don't talk with Miss Love, and that's fine. I like that. But Judge, I'm not going to stand here anymore.
Hold on, I was blocking Miss Love's face for you. Watch Miss Love's face.
Prosecutor of another member of the bar. I don't talk with Miss Love, and that's fine. I like that. But Judge, I'm not going to stand here anymore. I don't care. You can take my bar card.
Mr. Steele, listen.
Wrong, though.
But they're,
And Mr. Williams, to me, this is an innocent man. You talk about, Miss Love said there's a man in the Fulton County Jail. He shouldn't be there, Mr. Copeland. Mr. Williams shouldn't be in custody. But he's been charged, and we come here for a fair trial. It's been everything but that, according to Miss Love has tried to demonize me. At times, Mr. Adams. At times, Mr. Shaw. Now it's Melnick. All because she wants to win the case. And now she speaks over people. It's not right. I gave them everything. And by the way, and what I want to tell you, by the way, it's not even the law. If they call that gentleman on direct, I don't have to give them anything before trial. I do it because you asked me to. You said, listen, we got a big case. It's going to take a long time. Give them things. I gave this, by this way, to the state, October of 2023. October 2023, that was uploaded, given to the state. I hear about it now, and I
Okay.
wait there and I give them the exact duplicate of what we have. And now there's a false allegation of misconduct.
but-
And what I'm telling the court is what I said again. I do not appreciate it. And you have told it in front of the jury that I'm unprofessional. You were wrong. You based that on Miss Love's false
Your
representation.
Honor, again, the ad hominem attacks, Your Honor. I object, and he should stop talking when I object.
Try to silence me.
Yeah.
Will not be silenced.
But Mr. Seal, here's the thing, okay? I think
Hold on. Miss Love objecting is so funny because she filed a motion in limine mid-trial, her request being to ask the judge to stop sustaining so many objections from the defense, leading question objections. She filed like this 2-page, hastily written, didn't make sense to file when she filed it, except if you consider that it came right after, Brian Steele was held in contempt and all the Gachdel lawyers came in. Steele, Miss Love ran and filed this 2-page motion in limine mid-trial asking for the judge to instruct the defense to stop objecting to so many of her questions. And now she's like, if I object, you need to stop. Well, if you're objecting to cut someone off from stopping, like, first of all, it's not like the jury's here. Like, let him finish his reasoning. And this is the reason for it. This is really the reason for it. I didn't say it. Trap Addict said it. And then I want to say thank you. Thank you, Deanne Thomas, for $1.99. Yeah, we need the recorded version of the transcript. Now, I do want to mention, a lot of people have pointed to the length of the transcript as being suspicious, like there's a lot missing. But just keep in mind that any time where Woody may have been reading or pretending to read a document that was handed to him, or Olive Glanville's that really adds a lot of time. I do think if things were removed from that transcript, they were key details. Those transcripts still look bad enough, even if they have any redactions of any kind. They still look bad enough. In fact, I would say they look worse for the prosecution than I expected. Because they spent 56 pages still trying to convince a witness who's saying he's going to lie, who also says, I did these crimes, to continue to take the stand and give them the testimony that they want him to give them. 56 pages of transcript to make that happen after they've been cordially speaking with him for a week about his testimony. Good stuff. Thank you for the $1.99, Deanne Thomas, and for the opportunity to rant. And then, yeah, I mean, this all we're going to hear the theme today, there is no emergency. The whole reason that they're going to have this meeting on Monday is because they want to make sure Woody testifies. The whole purpose of it is to make sure he's still going to testify. And they're still going to pretend, when Brian Steele inquires about this ex parte meeting, well, you don't know why. It could be for safety concerns. There could be a reason that we had this ex parte meeting and didn't disclose it.
Mr. Steele, please be quiet at this point in time. You made your point. You made your point at this point in time. Both of you, please be seated. Please be seated, sir. Sir, please be seated.
Whatever you do is fine, but I care about Jeffrey Wood.
Sir, it's obvious. I would expect no less because you're his advocate, you're his champion. But could you all please sit down so I can kind of figure out a solution for this? All right. First, let me just kind of address the obvious. I know that tempers have been heated in this particular trial, and they continue to do so. And I know that all of you are being zealous advocates and representing your clients to the best of your ability with zeal and rigor. However, I agree that, there should not be ad hominem attacks on anybody or any counsel, and that you all should think and reflect about what you say about your brothers and sisters of the bar. Because we have a large contingent of folks that watch this trial. And so not only for the purposes of this, but it sends not the message I think you want it to send. All right. So I'm going to leave you all to your wise discretion in order to do that. But I'll take up whatever I need to take up as I see fit. But I know that you all, this has been a long trial. It's very demanding, exacting, and grating on and tiring on all of you. So I ask you to just take a couple deep breaths and step back and see and kind of look at and just remember that you do represent who you represent and what you're here for. In terms of the tape or the phone calls from Fayette County, it's the court's suggestion that, and if you want my assistance, I can always, with a proper subpoena, have the raw, whatever it is that whatever you're seeking to get, I could get that, and you can compare that against what you have. Because maybe that's what, I mean, and Mr. Steele, I don't doubt, and I know that you would never delete or otherwise try and alter evidence, and I assume that that's what you got, and I'm gonna take that at face value. I'm in no way saying that. Ms. Love is in her argument is saying that she is, when it's stripped down, less all the sound and fury, she's saying that particular type of file has other things with it. I don't think you were given those, and that's what she's trying to get. So I'm in no way blaming anybody in this particular circumstance, but if you want that particular file, and I think you all should have that the raw file, then let me do a notice to produce or a rule nisi, and maybe we can get the entirety of the file. And I think that if you did that, I think that the whole thing would probably be produced to you, because nobody probably wants to come down here and see me. So I will work with you all to get that, and you all we can take that up. And it's a problem I think can be resolved. But I'm in no way. But I would just remind everybody to be careful about what they say to each other. Some things you just can't take back. And remember, y'all going to see each other over and over and over again. And, you know, it serves you and serves the profession, serves your clients. It's not effective. So just please consider what I just told you. All right. So I'm just going to recess, and we'll see where Mr. Melnick is at that point in time.
Okay, so I have the other timestamp when they come back from the recess. But like, is there anything that you guys see that's exonerating? Like, play devil's advocate in the chat, you guys. Is there anything coming out of this hearing that makes you feel like the Monday ex parte meeting was justified? Or, you know, maybe, I guess one way to give grace would be if they just wanted to find out he was going to show up and be willing to get on the stand and didn't expect the meeting to turn into 56 pages worth or whatever of recorded conversation. I don't know. Like, do you think anything so far in this June 7th hearing makes how we felt about this ex parte meeting? Does it settle you down? Does it make you feel the same? It hasn't changed your mind at all? Does it make you look at it worse, in a worse light? Because for me, I'm just like, this looks like they just do this all the time. And Ghost, shout out to Ghost for being a member for 3 months. Good to see you, Ghost. They had off the record conversation guaranteed. Yeah, and we find out in the transcripts, particularly with Woody, that they met with him a few times. Hilton met with just Woody, and they didn't record the conversations. So, great stuff. Great stuff. And Road. So I think some people are familiar with this, but a lot of people might not be, and it's a great refresher. So Road Dog says, you guys are forgetting that Miss Bennett told us that Detective Hamilton told her she better show up. Miss Bennett was a witness. Detective Hamilton said she better show up, or they will get a warrant out for her. The DA got the judge in their pocket, and it shows now. So the reason this comment is a little bit twofold, because if you guys were able to catch the video I did talking about Ashley Merchant's reactions to the ex parte transcripts, Ashley Merchant points out that for the prosecution and even for the judge to not understand the significance of Melnick wanting to withdraw or Melnick taking issue with the fact that he knew his client planned to get on the stand, planned to plead the fifth, planned maybe to not even be truthful. For the prosecution and the judge, not just to ignore Melnick's grievance or concern, but to try to spin it and make it seem like Melnick was the bad guy for that big FU email that he sent, apparently at Thursday, 6 p.m., 6 p.m. before the day that we're watching right now, June 7th. Ashley Merchant says that's easily recognized in the criminal defense world as a noisy witness, because you're not supposed to, and it mostly falls under candor of the court, but you're not supposed to knowingly, a lawyer shall not knowingly let falsity come across the tribunal, come across the court. So if you know that your client's going to lie, you're in this kind of precarious situation that the bar understands can happen. And one of the remedies for it is for an attorney to withdraw, because it's kind of a middle ground. Judge, look, there's something's not right here. And if I were to get specific about what it is, it could make me have to divulge attorney-client privilege information. I can't do that either. So I'm asking you to let me withdraw from my representation of this client. That's one way to kind of like hint to the judge, there's a problem. I don't want to be helping put a witness up on the stand and letting them put forth testimony in front of a jury that I have reason to believe will be false, or that they may get up there and plead the fifth, which is extremely prejudicial for the jury to hear. But we have this whole June 7th hearing so far where that's the bigger part of it. The second part is shorter. They're really just making Melnick seem like he's crazy and the bad guy. And I was really glad that Ashley Merchant took the time to react on X. I don't know if she's that active on X. This is kind of active proceedings. It's paused, but she's still helping to represent Brian Steele relating to the contempt that's all spurred out of this ex parte meeting. And for her to comment and say, look, it's a bit ridiculous that the prosecution and the judge are acting like they don't know what a noisy witness is, and that they don't know that it's problematic if an attorney knew their client was going to do such a thing and then decided to do nothing about it and just let it happen. That'd be in violation of their duty of candor to the court. So, a lot of funny business, going on. I don't really think there's an excuse for it. And yeah, you guys are all in the chat. Everyone says shout out Lil Woody. Cheers, Lil Woody. And that's crazy. Lil Woody, even though he says I did these crimes, I lied about everything I told the police, I feel like he was way more honest in that ex parte meeting than we're seeing from the prosecution from the state here. So, let me get to the second timestamp, you guys. And I forget this other attorney's name. He came in. We're going to hear from another attorney, and I love that exchange too. That's going to be a good one.
And we will certainly take up with that knowledge before. Collect your thoughts and please be seated. All right. Mr. Melnick, welcome back. The time is 2:35, I should say. Did you have an opportunity to talk with your client?
I did.
All right. Who is going to be here on Monday?
Kayla Bumpus.
Kayla Bumpus.
B-U-M-P.
Sorry about my boomerang.
All right.
And I can state, as Mr. Copeland's attorney of record, told him, are you sure this is what, asked him, are you sure this is what you want to do? And he said, yes, he intends to assert his Fifth Amendment privilege again on Monday.
Okay. Well, I will, if you would tell Ms. Bumpus she needs to be here at 8:30, and we will certainly take up with that knowledge before we call our jury, and I will ask him in her presence whether or not he intends to do that, and we'll see where we go from there.
Okay.
Okay. All right. Anything else?
No conversation.
Okay. All right. Sir, enjoy your time off. Okay. All right.
Before we have some of the defense counsels, raise some issues with the court, shout out to Penny G for the $5 super chat. Penny G says, only in the transcripts, they didn't mention personal safety. Quite to the contrary, the judge said that's a collateral secondary concern. So, and again, you guys have mentioned it in the chat. A few of you have pointed out that, Kayla Bumpus has discussed on, I know she was on with the lead attorney. I know she's been on with Talk That Law too. But I think in her recent interview with the lead attorney, she had mentioned, they're kind of missing the beginning of the ex parte meeting. When the transcripts start, when Kristen Weaver says, are we ready? Okay, we're on the record. it seems like from Caleb Bumpus that something happened before that. And just from context, it seems like it starts in the middle of nowhere. It starts with Love kind of rambling. But Kayla had said, you know, it was her and Hilton at first that morning when Kayla first got there. And we also don't have in the beginning the court coming on the record and saying, all right, we're calling this meeting here to deal with the matter or the issue of blank. This is the reason. We don't have that laid out. And if the cover, the excuse, the justification for this ex parte meeting is safety, has anyone been able to find that anywhere? Because not only what Penny G is saying, the judge says that that's a collateral secondary concern, but right in the beginning of the transcripts, and maybe if we have time at the end, we can pull them up and look at it again, Love seems to laugh and mock the idea that Woody could be killed for giving testimony in this trial, for being a witness in this trial. She laughs it off and then just goes into, like, honestly, an egotistical rant about, well, I'm not going to be the one that kills him. The prosecution's not going to be the one that kills him. Like, don't play stupid. Nobody was saying you you specifically are going to be in the kitchen with the candlestick taking out Lil Woody. Someone was just expressing concern. Melnick was expressing concern that you're going to get him killed by putting him up on the stand in this way, having to testify indirectly by any means. He could be killed because of this. And they laughed about it. So not only was it a collateral secondary concern, Penny G, but it was something that Love, if Melnick thought it was a concern, Love found laughable that it was a concern. And that's really one of the reasons I said that that transcript looked worse for the prosecution than I expected. Like, just crazy. And hold on, yeah, let's not forget that since that time, Lil Tay has now died. Is it Lil Tay? It is Lil Tay, right? Friend of Woody. Woody has shared and expressed his condolences. There's rumors that he was possibly killed near or in an apartment that Woody used to be at, or maybe it was Woody's apartment. I'm not going to speculate because I don't know the details. But Woody expressed condolences, showed pictures of them being friends throughout different years. He coincidentally gets killed last weekend. Obviously, it could be for any number of reasons, right? We don't know for sure, but it is coincidental timing. And then you have a prosecutor who's using an immunity deal to remove Woody's right to plead the fifth, to invoke the right against self-incrimination. That immunity deal was to remove that privilege. That immunity deal wasn't to keep, there's no deal to keep Woody safe. Love is laughing that Woody might be killed. There's no possibility of that. The sole purpose of all the maneuvering up until this Friday and then again on Monday morning is to assure and reassure that Woody will deliver the testimony that Hilton's looking for. It's crazy. I'm going into another rant again. They put him in the jail. They don't give him a PIN number. He can't call anybody.
Okay, counsel, is anything else I need to cover with you before we recess until Monday?
Got it.
Yes, Mr. Botts. Mr. Botts, you need to use the microphone, sir.
Is it working now? Can you hear me fine?
Yes, sir.
All right.
Shout out to Mr. Botts.
Whole fiasco out with whether the state knew that Mr. Copeland was going to take the Fifth Amendment when he took the stand. And if so, was that proper or improper to put him up on the stand knowing that they were going to?
You have to speak up, sir. And if you could hold the microphone, it'd probably be better.
That he was going to assert the Fifth. And I know that they did know that he was going to take the Fifth because I heard it said outside right before I walked into court. I even said, the officer.
Then why didn't you, as an officer of the court, tell me before we took his testimony?
I told Mr. Steele.
No. Why didn't you, as an officer of this court, tell me?
Well, then that's my.
I got a problem with you now.
Well, that's fine.
Put a 1 in the chat if you think Judge Glanville used the same tone of voice he's using with Mr. Botts right now with Hilton and Love during the ex parte meeting. Do you think he used this tone? Put a 1 if you think he did. Put a 2 if absolutely he did not use this tone of voice with Miss Love or Miss Hilton. Shout out to Mr. Botts.
I mean,
I got a problem with you now.
well,
I would suggest you don't say anymore.
I've already said it.
I know that, sir. And the problem is you should have told me if that were your case, then you just made an argument we didn't even need to have, because I could have certainly asked him based upon your proffer. Now you want to have it both ways. You can't do that.
Your Honor, I thought the state knew that, and
And that's not what the point is. The point is you as an
The cameraman
advocate,
doesn't know where to go.
You should have told me. Both sides have an equal responsibility under the rules of professional responsibility.
okay, as long as we're both responsible, that's fine.
All right, have a seat, sir. Thank you.
Your Honor, I have a request of the court. Is that okay?
No. What's your request, sir?
So in the attempt to avoid any spurious allegations moving forward, I would ask that Your Honor order that the deputies transport Mr. Copeland to the jail completely separate from any.
Yeah, thank you for reminding me of that. In our order, wait, just 1 second. In the order of the incarceration, I'm going to, I also have a keep separate order for him.
Your Honor.
For the transportation and the housing, because none of these gentlemen are going to say anything to him, but I don't even want anyone to claim that he did.
I think that that's fair enough, and that's a good suggestion. All right.
We'll prepare.
Yes, Lieutenant Walker. So that will not be an issue? Okay. Okay. But we'll go ahead and have him, if you could also have him housed separately too? Okay. Okay. Thank you. Thank you, madam. All right. Anything else, counsels? All right. Take a couple deep breaths this weekend, take a knee, and come back on Monday and let's get after it again, okay? All right. We'll see you on Monday morning at 8:30, okay?
Can you get us the list of names and then any exhibits for Monday?
I think the only, I don't know who is being called. We can find out. Ms. Lovett and Ms. Hilton and Mr. Atkins.
Now, this is important, and we've talked about it, but, you know, it's not speculation that the prosecution, I think this was like, what, day 83 or something? Who knows? We're at day 100 now that the trial's paused. If we come back and have another trial day, it'll be day 101. But we made it like 80 days into this trial, all these witnesses, everything. And then this Friday, they want to call Copeland when Melnick's going to be out of town on the Monday. They haven't gone through the video footage. They don't know what they want to play. They haven't prepped the witness. And then what else are we going to find out? Well, we're having this issue with Woody that you've had like 5 days now to know would be a problem, because he's told you himself he doesn't want to get up there and testify. He's going to plead the fifth. And even with an immunity deal, he's still going to plead the fifth in front of the jury. Listen to what the state says here in response to Steele and Glanville's question. Well, who are you going to call on Monday? Is there someone else you can be prepared to call?
Who is going to be called? Let's assume that Mr. Copeland invokes again. Do you have some other witnesses that we can take up at that point?
Your Honor, we will apprise after we look at and reevaluate where we are, because our order of proof was building blocks that at this point began with Mr. Copeland. And there are certain things that have to take place before we can tell them anything. So we have to do that. We have to deal with that and where we are right now.
All right.
And that's just where we are.
Okay. We'll be thinking about what scenarios you'd like to have the court look at,
Yes, Your Honor.
depending upon whether or not Mr. Copeland decides he'd like to invoke his privilege again. Okay.
Yes, Your Honor.
All right.
And Your Honor, go ahead.
Madam.
Mr. Sharp, you can have the floor.
Yes.
I'm just going to ask the courtesy of the deputies, could we just keep our clients here for just 5 minutes after court ends, 15 minutes after court ends? The attorneys would like to have a discussion with our clients.
Lieutenant Walker.
And Your Honor.
And hold on, does my mic sound better? Because I just took off StreamYard's auto mic volume adjust and like kind of put it at an arbitrary level. So let me know if this is better, Kilroy, and thanks for letting me know, because that's important. I'm not trying to make you guys deaf and give you hearing problems like Woody Copeland has. And then shout out to Brian Wilson for the $5 super chat. Brian Wilson says, in the transcript, prosecutor said, quote, "We keep saying yet, but no one had said yet. Something's definitely missing. Yeah, guys, and there's a lot of, I'm not saying there is or isn't something removed from that transcript because I think it's bad enough either way. But there are a lot of questions that you could raise. And I think it's reasonable to be suspicious because Glanville initially said he was going to redact them and then was like, oh, I'm going to give them to you in full. Well, how do we know that he wasn't saying, I'm going to give them to you in full? So, okay, and thanks for the feedback on the mic, you guys. I appreciate that.
The state has a matter we need to take up ex-parte.
Okay, all right. Lieutenant Walker has been asked by defense counsels, as a corporeal body for them to be able to talk with their clients, once you clear the courtroom.
Yes.
Can you make that happen?
Yes.
Okay, all right. So once everybody is, cleared the courtroom, you just secure it, let them be in here alone with their clients. Okay? Oh, yeah, once we go down.
Okay, I'll make it happen.
Okay, all right. Okay,
One last thing, Your Honor. I just thought of this. Your Honor probably already thought of this. The no contact order.
Separate housing.
Mr. Copeland should probably also include not just these gentlemen, but other gentlemen that are on this indictment that are not sitting for trial. I think that would probably be. Okay.
okay, all right. All right, okay, we'll see you Monday, okay? 8:30.
We'll see you Monday at 8:30. So who are they going to see at Monday? On Monday at 8:30? We're going to have Hilton talking to Copeland. For whatever reason, we see that in the transcripts. Let me pull those up in case we want to go through any nuggets. Because if you guys see Ann Stuff in the chat, Ann Stuff, are you still here? Ann Stuff went through and made some annotations. And I put them into a Google Doc. So that way it's accessible and easier to read. But there's a link to this doc. This was all by Ann Stuff in the chat. This was not me. So shout out and give all your love and appreciation to Ann Stuff. But punch through line by line of all the highlights of the transcript. And honestly, we could add to this, right? If we crowdsource, we'll probably be able to find that every single line in this transcript is interesting. But really a lot of highlights here. And let me pull up the actual transcript. Make it bigger. And also, if you guys didn't hear me say it, the initial file that was going around of the transcript, it wasn't OCR'd, it wasn't scanned and searchable, but now you can hit Control F if you want. There's a link to a searchable PDF in the description as well. So if you want to search for, you know, how many times Love talked versus how many times someone else talked, you can do whatever. And then let's see. Anything interesting that you want to relook at in this transcript? I want to look at the beginning. What we had happening, we're going to find out later in the transcript. We're not going to reread the whole thing. But we find out later. We know Hilton's missing. We were wondering why Hilton was missing. Where's DWC? Where's Dear Woke Christian? I know he's in the chat somewhere. But when we were reading it right when we started, we read this description here. And, you know, ex parte meeting begins at 9:10 a.m. Present in the chambers was Judge Glanville, ADA Adrian Love, Attorney Kayla Bumpus, Court Reporter Kristen Weaver, and investigators Antonio Long and Rashid Hamilton. So Woody's not in here yet, which maybe that's not necessarily weird. It's still ex parte, but it's not necessarily weird that Woody, the sworn-in witness, isn't in there yet. But where's Hilton? And we find out later that while this really conversation between Kayla Bumpus and Miss Love is going back and forth, Hilton's been talking to Kenneth Copeland the whole time. Which is just, why? Like, I don't have an answer for you guys. I'm curious. I don't have an answer. And then, so let's clear that up too. So Kimberly says, Love just asked for ex parte meeting. So did it start Friday? Glanville didn't want to have that meeting. He wanted to start that off on Monday morning. Although I really think, because we know Glanville and his time frames, I do think that Glanville probably thought it would be a check-in with me, make sure Woody's good to testify, that, you know, he gets transported over from the jail and he's good to go on the stand and we can get out there on the floor in front of the jury. I don't think he expected paragraphs and paragraphs of arguments from Miss Love complaining that Melnick used the F word at her. Like, maybe he really didn't expect that this meeting would go so long. That's not an exoneration because the defense could have just been invited. It could have been disclosed to them. All of those problems still exist. But I'm just saying, Love wanted that meeting. Glanville was like, nah, we'll just do it Monday right before the jury seats. Not realizing that Love was going to, I don't know, what was it, like 30 minutes, 35 minutes Love was talking for. Then Hilton comes in and talks for close to an hour, in and out between off the record conversations for Kayla to speak with Copeland. Let's see. I'll tell you right now, my favorite part was I loved Woody for the end here. We're going to read this conversation. It's lighthearted, but there's a serious point behind it. So Copeland goes on and says, all right, after all this, I understand it's my desire to give testimony. And then the judge is like, well, do you guys have clothes for him? Hilton says, I don't know. Let me go take a look. What size are you? Copeland reminds them, I can't hear you. I have a hearing problem. Miss Hilton, what size are you? Little. And then Investigator Hamilton says, we had a large jacket for him on Friday, a large. And they go on, they're saying, you know, all his sizes and stuff. What size are you, small or medium? Copeland says small or medium. And then the judge says, we're going to try to get you some clothes so you don't have to testify wearing that jail uniform, okay? Now, this is the judge saying this. When a defendant is brought into court and the jury is going to be there, whether they take the stand or not, even if they're just sitting at the defense table, it could be prejudicial to the defense for them to be sitting in like the orange jumpsuit or in handcuffs or gagged or like whatever. Those things could be prejudicial because it just makes you seem like that person sitting over there did something wrong. The visuals, the appearance, it changes your perception of that person because of how they're presented. With a witness, if a witness was up there in a jumpsuit, who would that prejudice? If a witness is in a jumpsuit and that witness is perceived as less credible and it's the state's witness, that witness looks like a troublemaker because they're in prison clothes, in jail clothes, up on the stand as a witness for the state. Who does that negatively impact? Who does that positively impact? And here you have the judge trying to make sure, you have Glanville trying to make sure that a witness who isn't entitled to a fair presentation at trial, Glanville's trying to make sure the witness is presentable for the jury. And Copeland responds, y'all don't want to show the people how y'all did me. Y'all don't want to show people how y'all did me. Who's y'all? Y'all's not the defense. Y'all's not Jeffrey Williams. Y'all's not Diamante Kendrick. Y'all's not any of their attorneys. Who's y'all? And then so the judge tries to say, look, and then Hilton says, if we can't find clothes, then you may have to come tomorrow. So we made it 52 pages through a transcript, trying to get him to agree to get back on the stand today, right now, just get up there. And then suddenly, because Copeland wants to stay in the clothes he's in, he's sitting handcuffed in this chambers, in this ex parte meeting, in his jail clothes. Suddenly, because he's like, I'll go out there like this. Hilton says, oh, well, we may have to wait till tomorrow for you to testify. Mr. Copeland insists, I prefer to go in like this. Hilton says, I understand what your preference is. Copeland, nah, don't hide it. And then Bumpus butts in and says, can you make him put on clothes? And Hilton admits no. And Copeland says again, I want to go in there like this. And Hilton says, fine with me. So that's why that was the day. I think their jumpsuits there, like the blue collared, they're not as clownish looking. Some prison suits, they're like the orange, or they're the black and white or gray and white stripes, or the green and white stripes. His was kind of like, almost looked like a work shirt. It was like dark blue. I think he had a white shirt on underneath it. But still, they put up this fight all day to make him take the stand. And because he says, I want to go out there and let them know I'm coming from jail right now. After they know they heard me plead the fifth on Friday. And they had to go into recess, and then they were dismissed for the rest of the day. I want to go back up there now. You fought with me all day on this. I'll go up there like this. And they say no. Think about that. I know it seems like such a silly little exchange. I'm a small medium. I'm a schmedium. But this is really telling that Hilton was ready to throw the win away. We finally he says he'll go up. We finally get him to say he'll go testify. But we don't want him to look with this presentation. We don't want him to look a certain way to the jury because we need him to look credible and like a behaved member of society that didn't just spend the weekend in jail. Look at that. And then he says, you ain't going to try to lock me back up for this? And then Hilton reminds him, so long as you testify, we will get you an order to get released. And Kayla says, today. So that was really my favorite part of the transcript. Shout out to Dear Woke Christian who sends $5 and was also my transcript co-host. We read this together on his channel, and that was a really, really good time. And I appreciate anyone that's in this chat that followed us over there that night. It was really good conversations in the chat. I love seeing you guys over there and love having you here too. And Dear Woke Christian says, always good to hear your thoughts on these topics. Keep at it. I'm on it. And then, yeah, you guys are... And I agree. I really think Woody's street smart. I mean, you see his responses to these questions. He's playing with Hilton here. He's definitely playing with Hilton here. And you can see him do that on the stand once he gets on the stand too. And that's true too. So Drea's reminding us that with Miss Bennett, she had to testify the first day in jail clothes. So, because remember, they held her. And that's gotta suck because... Let me be careful how I word this, because I don't want to say that someone who has... If someone did something and they were convicted and they served their sentence and they come back out into the world, their sentence is done. So if Woody hasn't been arrested for anything and he was really just held in contempt, and Caleb Bumpus is here to help make sure he can purge that contempt, you know, it could be unfair to him to be presented on TV as someone that's incarcerated for something. But as far as Miss Bennett was, she had children too, right? I'm trying to recall. Miss Bennett had children. She was trying to work. She couldn't make all the interviews that this detective that was hitting on her kept wanting to hold with her. Oh, we got to meet. We got to talk about this case. And then it was time for her to testify. She didn't want to show up. And she made it clear she didn't want to show up because this detective had been harassing her. And the state kind of tried to withhold that reasoning to the judge, and the judge had to face the music when he was finally confronted with that. But she was initially held, and she had to get on the stand in jail clothes. Now, this is just someone that was trying to get to work. Didn't want to miss work to meet up with this detective that was hitting on them. And now they have to take the stand in a televised trial with everybody watching it in clothes like a convict. Like, that really sucks. That really sucks. And it just seems the threat of we'll put you up there, it seems like intimidation. And then actually putting someone up there in jail clothes. Woody wants to. He wants to go up there like that. But for Miss Bennett, that seems like a straight up punishment. And that really bothers me. And then Falcon Hoof says, this is the worst double dare ever. You're damned if you do. Damned if you don't. And this is really it, guys. We see in those transcripts, we hear a little bit of that in this June 7th hearing, but Woody tells them over and over he wanted to plead the fifth. He makes it clear. And yeah, hit the like button. Guys, YouTube is actually changing the way that your watch page will look. So I've seen a lot of you guys say, how are there only like 4 or 5 likes in here? You guys should go like it already if you haven't. I'll appreciate that. but YouTube is changing your display interface. If you've seen YouTube pop up on my screen, you see, if you guys haven't toggled the change already, it's rolling out for some users already. It's collapsing all the comments into a sidebar. So you'll have comments here, and then if the live chat, if this channel had live chat expanded, you could expand it and make the whole right column the live chat, but it hides the like button automatically when you join a live stream. So I believe this will be an ongoing thing. There is a feature change. There's some buggy stuff going on. I appreciate everyone who has hit the like button, nevertheless, but I don't think there's some weird thing where people are intentionally not liking the video. YouTube is changing the interface. I think it's okay. I don't love the change, but I don't dislike it either. And then, let's see. And then Megan, shout out to this. You don't do social media, you follow the court trials. And that's really important too, because you can go on social media and you really can see some things that, you know, a jury wouldn't necessarily see, right? So having someone like Megan in the chat, we can pretend you're closer to a juror. So yes, we got to watch some of these hearings, these moments where the jury wasn't in the courtroom, but you're still more constrained in what you're consuming about this case than someone that's, you know, like me, watching Lil Woody's Instagram live videos and hearing what he's saying out there. So I think it's always important to have different feedback, different input from people that are consuming this case in different ways. And then, yeah, the transcript says so differently from what was argued in June 7th. And guys, just so you know, there are links. If you go back to my channel, actually, let me just pull up a link. Dear Woke Christian. I did a full reading with Dear Woke Christian. Has everyone in the chat read the transcripts or listened to the transcripts, however you consumed it? There's the ex-parte transcript reading party we had over on Dear Woke Christian's channel. If you guys want to check that out after this, because we're going to wrap it up. I mean, we got through the little big updates that Steele has filed a case now against the state of Georgia with the Supreme Court of Georgia. So that's going to be great. We clarified some stuff that we talked about in community posts and other places. Tons of links in the description of this video too, you guys. If you've missed anything this week, you can go and check that out. And I'm going to do one last check because you never know. 5 p.m. rolls around and sometimes things get e-filed. Anything new? No. And let me refresh the Fulton County and see if there's anything new filed. It's 5 p.m. is that time. And then what is the case number? I'm surprised I don't have this case number memorized yet. Plug that in. All right, so I don't see... The last thing I see from Jeffrey Williams is the notice of docketing. They're sending over the record from this trial over to the Supreme Court for the case that Brian Steele has filed. And I'm really excited to see that, guys. As soon as we get anything on that, hit the bell. We'll go live. And then other than that, it's still the motions that we saw yesterday. Nothing new. So let's close it out here, you guys. It's always so awesome. It's a little bit overwhelming in a good way to have chats that are so big, but I really love it. And I love being part of it. So I can't wait to see someone else go live and see some of the faces that are here over in another chat. I appreciate it so much. Big shout out to Drea. You guys showed Drea some love. Not only is Drea a great mod, but she brings so much value to the chat. She comes with so many details. And she also gave us the 114-page proffer document. That's shared in a community post as well as in the link, the description to this video. Also shout out to, I know Julie has contributed a lot of information and Stuff has contributed a lot of information. Like so many of you. We'd be on here for another half hour. I'd have to read every name in the chat. But I really do appreciate it, and it's so much fun to have you guys here. I really appreciate it. You guys all have a good one. If you celebrate the 4th of July, have a good one. And remember, July 8th, as of right now, the state is supposed to respond to these recusal motions. They're supposed to respond. Maybe something will put a wrench in that plan, but we might have an interesting filing at 4:59 p.m. Eastern on Monday, July 8th. So hit the bell and plan for a live on Monday night. You guys all take care until then. Thank you so much, as always, all of you. Bye.